The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Welcome to today's webinar, Getting Them In When They're Out, Immigration Options for LGBT Foreign Nationals and Their Families. We are presenting today's webinar. Myself is, Joseph Shepard here in the Santa Monica office. I'm joined by Adam in the New York office. Adam, can you hear me?
I can. Hello, everyone.
We are presenting today's topic to give more information to individuals and employers about the current state of immigration law for foreign nationals who are in same-sex marriages, same-sex relationships, or for individuals who are transgender and have entered into an opposite-sex marriage with someone of the other gender. There's a lot of complexities involved in this area of the law, but before we begin, I just want to give you some basic side information. This is meant for general information purposes. It's not legal advice. If you have specific questions, hold them to the end, but if you have a specific case-specific question, you can follow up by contacting Adam or myself after the webinar. But what we're going to do today is to provide the overview of the current state of the law, and then we'll talk about, how immigration law is impacted by the Defense of Marriage Act and what the available options are because of that, and then we'll talk about potential options after DOMA is either struck down or repealed in the event that it is, and we'll talk about why. The reason that we're presenting this webinar is because in an increasing frequency, employers are finding that their key employees or key potential employees are coming from countries where same-sex marriages are lawfully performed. Right now there are 11 countries around the world where they are lawfully performed. In the U.S., we now have 9 states, thanks to the recent election, where same-sex marriages are lawfully performed. So increasingly, these key employees are either married to or in a civil union or domestic partnership with someone of the same gender. And in those cases, there are special considerations for bringing that worker over and their families. So we're going to go over an overview of what's available and what are the special considerations for those individuals. So under federal immigration law, generally, without considering the Defense of Marriage Act, the law of the place of celebration controls. So if the marriage was valid where it was performed, if it was not in bad faith, and it's not contrary to the public policy in the state or jurisdiction where the couple resides, then it should be valid for federal immigration purposes. This has been the law before DOMA was enacted. Because of DOMA, we've now woven into the system some special considerations which complicate matters significantly for certain individuals. Because of DOMA, it's not as simple as that. We have now a new federal definition everywhere where marriage or spouse is mentioned in federal law, including federal immigration law. We define marriage as between one man and one woman, and we define spouse as either a husband or wife of the opposite sex. So that complicates matters significantly, and in situations where the marriage was otherwise validly performed abroad or in the U.S., was not in bad faith, and is not contrary to public policy in the state where the couple resides or intends to reside in the U.S., because of DOMA, we cannot classify those marriages, otherwise lawful, as marriages for immigration purposes. So this has a number of implications for, practical implications for a number of individuals. Before we jump into that, I also want to mention that because of DOMA, marriages between a transgender individual and an individual of the other gender still can be recognized under the current administration under DOMA if the transgender individual has legally changed his or her gender and then subsequently marries someone of the other gender. In California, you can legally change your gender with a court order upon showing that you've completed all medically necessary and appropriate treatment. Specifically in California and under the current policy of the administration, showing sexual reassignment surgery is not required. The marriage has to be recognized as opposite sex because of DOMA under the law where it took place. The law where the marriage took place cannot specifically bar recognition of a marriage between a transgender individual and a person of the opposite sex, and the marriage can still not be in bad faith or contrary to public policy. So back to the implications of what DOMA has on the normal procedures for immigrating to the U.S., either coming temporarily to work or in the long term. The ability to file an immigrant visa petition or a petition to classify your fiancé for immigration purposes, you cannot file those for a same-sex spouse. They will not be approved. The current administration will deny them and specifically will not hold them in abeyance until this policy is done. Until DOMA is either struck down or repealed. They have said repeatedly that, as a matter of policy, they will not hold them in abeyance. They, arguably have the power to do so, but they have not done so yet. There's also implications for folks who are coming and visiting and are filling out the I-94 form on the plane before they land, or are about to apply for a visa and are filling out the DS-160 online. There's a number of implications involved there. For example, if a binational couple are married in New York and one is a U.S. citizen, one is a citizen of another country, they were married in New York, they reside in California, one went abroad to go renew his or her H-1B visa, and now they have to answer on the DS-160, not just if they're married or single, but now there's a drop-down implication for domestic partner or other. And regardless of whether or not you find this offensive, a lot of people do, there's a question of whether they say, yes, they're married, or no, they're married, or yes, they have a domestic partnership because that's what it's recognized in if they reside in California, or other, and then explain with detail exactly what the situation is. Specifics for each individual will vary depending on where they were married, where they reside, and whether this is before or after an eventual DOMA repeal. But specifically, if you are in that kind of situation, you need to talk with an experienced immigration attorney to make sure that you know all of the available options and implications for each answer. There's also implications under DOMA for reporting a derivative spouse on an I-140 immigrant petition. So an employer who is petitioning for an employer for a green card, the information, the form asks for information about any spouses. Do you have a spouse who will be either adjusting or immigrant visa petitioning upon approval? So the question then becomes, if you're in a dual foreign national marriage where both are of the same sex, do you report your spouse on the I-140? So, and then there's also, the implications specific to the specific, the specific non-immigrant visa categories. So workers who are here on an H-1B or an L visa, for example, their spouses usually are entitled to a dependent status. For the H-1B, it's the H-4 category. For the L-1B, it's the L-2 category. Specifically for same-sex couples, however, because of DOMA, even if they were otherwise qualified to be considered an immediate relative or spouse, they will not be eligible for the H-4 or L-2 category because DOMA prevents them. But there is an option available, though, which we'll get into later, for those individuals. And then, of course, there's specific employment authorization document options for certain non-immigrant visa dependent spouse categories that are not available to same-sex spouses. And Adam will go over some more of the other areas of federal immigration law that are impacted by DOMA.
Thanks, JJ. And here we're talking about, it's important to recognize that there are generally two postures in immigration proceedings. One we refer to as affirmative, and that's when somebody is already currently in status or is entered on some type of visa or the visa waiver program, something of that regard, and they're affirmatively seeking a change in that status. So you can apply for asylum and VAWA, for example, in affirmative status. And then there's a different type of posture called defensive, and that's after what's called a notice to appear, which is the immigration charging document, has been issued, and you're ordered to appear for removal proceedings, which means that the government has initiated a prosecution against you to remove you, from the United States. And so, so these categories it's important that there are those posture differences, the affirmative and the defensive postures. For many of these, these categories that are listed here for asylum and for VAWA, which is the Violence Against Women Act, for cancellation of removal and for certain waivers of inadmissibility, you can either receive as a benefit benefits if you're the spouse of somebody who is the primary applicant and has been granted those benefits, or if you're in a defensive posture for cancellation of removal and for certain waivers of inadmissibility, you are required to show ties to a U.S. citizen, and the spouse is one of those recognized immediate relatives that you need to show hardship to in order to obtain the benefits in that defensive removal posture. And those are currently denied under DOMA as well. We will cover some of these categories of affirmative and defensive relief later on in the presentation, but generally we just wanted you at this point to be aware that there are benefits of relationship recognition that are denied under DOMA in these categories. And JJ, I'm going to turn it back to you.
Okay. So then the question becomes, now that we know what the implications are here, Adam, actually, can you hit that next slide for me?
I believe so.
There we go. So,
great.
Now that we know what the implications are, well, what does that mean? What are we left with? What are the avenues within which, without violating the law or violating or, rather misrepresenting anything to the government, staying everything on the up and up, what can we do to get these key employees here with their families? Or what can we do to bring our spouse here, either temporarily or for the long term through legitimate means, since I can't sponsor them directly for an I-130 or I-129F, or specifically if their spouse is not entitled to receive, the H-4 visa to come along with them or the L-2 visa to come along with an intercompany transferee. So we'll go over specifically, what is available in the non-immigrant context, in the temporary short-term context. For immigrant visa options, what are the options for folks for the long term, since a green card petition or application through an immediate relative of a same-sex spouse is not possible? What are the options available in the worst-case scenario if the foreign national spouse is placed into removal or deportation proceedings? Are there any available avenues through the waiver process for either prior findings of inadmissibility or prior removal orders or anything of that nature, or maybe unlawful presence violations? And then we'll also highlight some of the asylum, the current state of asylum law, and the specific options there for folks if it applies to them. So to start it off with the non-immigrant visa options, I'll talk about this. So in instances when one of the spouses of a relationship is a U.S. citizen or green card holder, and the other is a foreign national, the foreign national side of the marriage has to be extremely vigilant not to violate the terms of their entry into the U.S. or violate the expectations of their intent when they enter the U.S. Under the visa waiver program or certain single intent visas, what I mean, just to clarify by single intent visas, are the types of non-immigrant visa statuses that folks enter into in which they have to establish to the satisfaction of the interviewing officer at the border or upon landing in the U.S. that they are not here to stay permanently, that they have the intent to return home. More specifically, that they have a residence at home that they have no intent of abandoning. For example, people who enter on the B1, B2 visa, which is for tourists or business persons, business or pleasure basically. B1 being business activities, B2 being for pleasure or for vacation. The B1, B2 is very similar to the visa waiver program in terms of the expectations of your intent. There's a lot more restrictions on the visa waiver program for being able to change or adjust status. Specifically, there almost are none. If you enter on visa waiver, it's assumed that you're entering for a short-term period for a very short-term and specific purpose. There's basically all but one, maybe two avenues from which a visa waiver entrant can adjust status to green card, none of which are, in this context, are available to a spouse of a same-sex spouse of a U.S. citizen. The single intent visas, a little bit more flexibility in terms of being able to change status or potentially to adjust on through other avenues than the family-based categories. But other single intent visas include the F1 student visa if you're coming here to get a bachelor's degree or to engage in some full-time course of study at an approved organization. J1 visas are another type of single intent visa. That could be a trainee or a postdoctoral scholar or an intern. An H3 is another version of a single intent visa, which is another type of trainee visa with more specific requirements for returning home. The reason I'm going through this with a little bit of specificity is because these are the types of visas that, while yes, a person can enter the U.S., their primary intent has to be the reason for which they qualify for that visa. So if they're coming here on an F1 visa, their primary intent has to be to complete that full course of study at that approved organization. It cannot be for some other reason. Now, that being said, if someone entering on a single intent visa or the visa waiver program has an immediate relative in the U.S., or rather has a partner or spouse regardless of the gender or sex of that person, it tends to be a big red flag for immigration officials at the border that they may have some other long-term immigrant intent. So folks on those types of visas or entering in the visa waiver program for some specific purpose, and it has to be legitimate and short-term duration, really need to be able to demonstrate that they do in fact reside abroad, that they do in fact have no intention of abandoning that residence abroad, despite the fact that they may have someone in the U.S. That they will either visit or see in addition to their primary purpose here. That being said, though, because of this area of the laws, it becomes so complex, you really need to carefully plan ahead if you are encountering either an employee or a potential student who are coming here and they want to bring their spouse with them, or in addition to their spouse, their children. And there's a whole lot of more issues there involved with the adoption or parental rights. Now, the next item on this list is the dual intent visas. These are also non-immigrant visas that, yes, you have to be entering for, you have to be intending to complete some sort of temporary or short-term durational project. You don't necessarily, and there are varying degrees of the dual intent, all the way from you can intend to permanently reside here as well, like the H or the L, in so much as you can have a petition filed for you and maybe even an adjustment application pending for you, and still be able to enter the U.S. So those are the full dual intent. There's only two of the two visas that are full dual intent allowed. Those are the most ideal in cases where people can qualify for a non-immigrant work visa, but also have potentially a same-sex spouse in the U.S. As long as you qualify for that intent visa and you're actually working for this company, for example, the H-1B, the specialty occupation visa, requires at least a bachelor's degree in a specific field of study in a position that requires the application of an area of specialized knowledge, usually associated with a bachelor's degree in that specific field of study, so that you have to actually be working in a position that qualifies. You have to actually be qualifying. And that allows, with that H-1B then, you have the ability to enter the U.S. without having to establish that you have a residence abroad you have no intent of abandoning. You're allowed to have the dual intent to be A, temporarily here, but B, the long-term, more abstract intent to eventually become a green card holder. The same with the L1A or L1B, for example. The dual intent applies to those categories as well. Those are intracompany transferee visas. If you have any specific questions about those, we can get into it afterwards or during the questions. So in situations where both spouses are foreign nationals, because their marriages are not recognized, let's say that they're a couple married in the Netherlands or a couple married in South Africa or any number of the 11 foreign countries where same-sex marriages are validly performed. Let's say one spouse is coming to the U.S. We'll start with the work visa context. Let's say that one of the spouses is being transferred. They work for a large multinational company. They're being transferred to the U.S. In an executive or managerial position for at least, let's say 3 years. And their same-sex spouse, however, wants to come with them. The company then says, well, what do we do? The same-sex spouse won't qualify for the L2 dependent category, usually allowable for an opposite-sex spouse. The L2 visa is extendable just like the L1A visa, in 3-year increments. They're eligible for work authorization while they're in the U.S., so an opposite-sex spouse otherwise would be able to file to get an employment authorization document after they're here. Let's say the assignment only lasts 6 years total. They only have to extend once, and so they only have to pay that filing fee of $290, whereas the same-sex spouse in the same position isn't eligible for the L2, and through transitive is not eligible for work authorization. There's one area, though, in the non-immigrant visa context where the Department of State has been allowing folks to enter the U.S. instead of in that L2 or H4, enter in B2 as an accompanying member of the household. So they call it specifically B2 classification for cohabitating partners. And they go into specifically what the definition of a cohabitating partner would be to qualify for the B2. It's very important that for folks in this situation who are coming to accompany the principal non-immigrant to specifically state in the visa application and to the consular officer abroad when applying for this visa to be endorsed into their passport that they want it to be annotated with B2 for cohabitating partner, and they will potentially be able to be admitted in theory for an initial period of 1 year. Most likely it'll just be the 6 months. A lot of the consular officers, even if they do put that on the visa, whenever the person gets to the border with the visa, with that annotation, which is supposed to allow the CBP officer at the border to do a one-year entry, they will still just do the 6 months because they probably don't know about it, or it's their discretion. They can still do the 6 months if they want. That being said, to qualify for a cohabitating partner, the relationship has to be recognized as fully equivalent in all respects to a traditional legal marriage and grant the parties all the same rights and duties as a traditional marriage. So in that case, it would be, they would otherwise qualify for it, but for DOMA is a pretty easy way to say it. So for folks who would like to come with their same-sex spouse to the U.S. if they're being transferred here, either on the L1A visa, or if they're going to be working on an H1B visa, or if they're coming here with their spouse who is on an O1 visa as an alien of extraordinary ability or achievement in the businesses, arts, sciences, or what have you, and are not eligible for that dependent category, can still come in the B2. That being said, as I mentioned in the slide, they have to extend them every 6 months. So that's $290 that they have to pay every 6 months, as opposed to the opposite sex spouse who only has to do that once for the 3-year extension. So it's a lot more expensive, and you can't work if you were a same-sex spouse of a intercompany transferee or a specialty occupation worker. Now, the B2 status as the dependent non-immigrant also applies to some of the single intent visa categories. You have to further demonstrate that you have that residence abroad you have no intent of abandoning. This would be true for the B2, even in the case of those coming on with the principal on the dual intent visa. So there's a lot of considerations and a lot of special backbending and document production and preparation needed for same-sex spouses that do not apply for opposite-sex spouses. So this is something that employers have to take into consideration, and people facilitating either J1 or F1 folks coming over to study have to take into consideration as well whenever the family members want to come, and the family members happen to be a same-sex spouse. Then finally, there's also one other area. I'll let Adam talk about this for foreign diplomats and workers in international organizations.
If we have any foreign diplomats on the line, you're probably well versed in this, so I will not go through this in depth. But essentially, there is a carve-out from the sort of general rules that were outlined above for foreign diplomats who are traveling on A visas, which are diplomats of foreign governments, and G visas, which are diplomats associated with non-governmental organizations like the World Bank or the UN. Prior to this carve-out, spouses or cohabiting partners of such individuals were required to travel on either G5 or I believe it was an A3 status. I'm actually not 100% sure, but essentially it was a non-recognized status. And the State Department has since amended that policy and has allowed for a same-sex partner in foreign jurisdictions where a same-sex marriage is recognized to travel on dependent status. So that would be an A2 or a G4 status. And so again, if you're a foreign diplomat, you're probably well aware of that scenario. But the takeaway for those who are not foreign diplomats, I think, is that this whole, the whole non-immigrant visa options are very idiosyncratic and very technical, which means that in order for you to determine the best course of action for you, the appropriate thing to do would be to contact an immigration attorney who's familiar with these categories and familiar with the idiosyncrasies and whims of the State Department and the Immigration Service as it relates to same-sex couples. And I think I'm going to turn it back to you now.
Sure. Can you hit the next for me? Thank you kindly.
Sure.
So now, in situations where, so this actually applies for both binational couples and dual foreign national couples, where both spouses are of the same sex, if there's immigrant visa options outside of the family context, both spouses will have to independently qualify for their own green card. This means that if you are if one spouse is working for a company on an H-1B visa or an L visa, another spouse is, let's say, studying in the U.S. on an F-1 or something similar. Or for a binational couple where one is a U.S. citizen, the foreign spouse will still have to qualify independently for whatever green card they get because the U.S. citizen cannot file the I-130 or I-129F. So if they're here in the U.S. on some non-immigrant visa status for some valid purpose that they qualified for, the options available through employment, if they are lucky enough to be of the few, the top 5% in their field, or the most extraordinary, business person, actor, musicians, research scientist, doctor, visual effects artist, visual artist, anything of that nature, they may be able to qualify for an EB-11 immigrant visa petition. There's also the outstanding professor or researcher categories, the EB-12, and then the EB-13 multinational executive or manager, which is basically the green card version of the L-1A visa. There's also certain categories for self-sponsorship in the national interest waiver category. I just want to say most of the employment-based categories you need an employer to petition for you, the exception being for extraordinary ability EB-11 and then the national interest waiver as well. There's also you can possibly qualify through the PERM petition, the PERM application, and then an immigrant visa petition based on an approved PERM. The PERM is the labor labor certification application in which the U.S. employer runs recruitment to find and determine whether or not there are any qualified, willing, and able U.S. workers for a specific position. If there are not, and they can certify that, then it's possible for them to hire the foreign national through that way. The reason I'm bringing this up is just to show the complexity of, for example, maybe two spouses work for the same large multinational company, for employers trying to determine how and which way they can leverage having them both work in the U.S. for the company and eventually acquire green cards for both of them. Because if you get one for one spouse, as under current law, because of DOMA, they won't be able to have their other spouse accompany them with the adjustment or follow to join them through an immigrant visa petition. Another category that folks can independently qualify for outside of the family context is the investment-based immigrant visa petitions. So it's the EB-5 category. Generally, that involves investing typically $1 million capital investment into an enterprise that you're going to be controlling, and you'll be creating 10 jobs for U.S. workers. That's a long process. It usually involves investing around, or rather keeping your money in the investment throughout the process, and showing that you have control and you have the ability to control, and you will be controlling the investment enterprise. There's a certain subset within the investment-based green cards that apply for individuals who invest in economically depressed areas or regional centers, where the investment is cut in half, and in some instances it can be a passive investment where the 10 jobs are created by the actual regional center, and as long as your money is unrevocable and in the investment for the entire process in the regional center does well enough to stay in place, you might be able to acquire your green card without conditions after a certain number of years. The final category, which has been in the news lately, is the diversity visa lottery, where every year 55,000 visas, roughly, give or take every year, depending on how many are left in other categories. But 55,000 visas are issued to individuals who qualify, who have entered the green card lottery. Every year they pick about 100,000 visa lottery quote-unquote winners. These individuals then have to go through another kind of lottery within a lottery to demonstrate that they are in fact qualified for this visa, which means that they have at least a U.S. high school diploma or equivalent. Equivalent doesn't mean the GED. It means the foreign equivalent of a full 4-year high school diploma. Vocational doesn't count. There's also a work experience component if the person doesn't have the equivalent of a high school diploma. And a lot of people in binational same-sex relationships or even dual foreign national same-sex relationships find that the visa lottery can be their only saving grace. However, not every country is allowed to not foreign nationals born in every country are not necessarily allowed to participate. There are some countries that are taken out of the lottery each year. So if you're interested in learning more about the lottery, you can go to our website and find the relevant information, or you can go to the Department of State's website, which runs it, and find the relevant information there about specifically which countries are allowed to participate. Keeping in mind that the country that you charge to whenever you enter the lottery is determined by the country where you were born, not necessarily the country where you are a current citizen. So we found that a lot of folks do find that the diversity visa lottery, even though it's a complete long shot, is a possibility. There's an interesting implication there when entering the lottery. A lot of folks ask whether or not that establishes that they have an immigrant intent, which would be a violation of the single intent visas or the visa waiver if they had an immigrant intent. Well, the answer to that is consider if you play the lottery. Do you intend to buy a house because you entered, the California lottery, the New York Lotto? You don't intend to buy a house. You intended to buy a lottery ticket. You intended to enter the diversity visa lottery. If you are selected as a winner from the diversity visa lottery, then you then submit an application for a green card. So your entry in the lottery is not an application in the sense that you haven't established your immigrant intent for practical purposes until you actually apply for it if you're selected. So the reason this has been in the news lately is that there has been talk of scrapping the diversity visa lottery in favor of creating a new green card program for individuals with high-tech degrees. It's called the STEM degree program. The science and mathematics degrees that folks on OPT know very well if they have one of those degrees. But for purposes of this presentation, we'll cut that off there. Just know that the diversity visa lottery is an option for folks and tends to be, not a bad idea to enter in each year. With that, we'll move on to the other areas and other, means available for folks because of DOMA.
All right, and I just wanted to congratulate everybody for making it through this far. I know, or we know that this topic can be rather dense and that it's very technical and that it's also very personal. So congratulations for sticking with us, and thank you for sticking with us. For a brief pause for station identification, this is Joseph Shepard and Adam Francoeur. We're both attorneys at the Wolfsdorf Immigration Law Group, and we are presenting, as you know, on the LGBT implications of, the immigration consequences and the post-DOMA landscape. We are going to sort of shift now from non-immigrant visas and immigrant visas to removal and deportation defenses and waivers. And again, in terms of the posture, what we're looking at here is sort of what we're hoping to avoid for those of you on the call. This is really when immigration becomes sort of a crisis and when an individual is facing imminent removal or is at least charged with removability from the United States. So this is after what is called an NTA, or a notice to appear, has been issued by the Immigration and Customs Enforcement Agency, which is charged with the enforcement of immigration laws, and is often, the first step in removing somebody from the country. Now, the overarching concern here is that we're really looking at an evolving landscape, and so while I'm going to cover a few of the hot topics, as it were, of removal and deportation defense as it relates to same-sex individuals and same-gender individuals, what you should know is that it's very, again, it's very specific, and so these topics may or may not apply to you in your situation, but certainly this is not legal advice, and you should not rely on them as the basis for how to proceed in your own personal matter. And the first topic that I wanted to cover is matter of Dorman, which is a recent case that was on appeal to the BIA, which is the first level of appeal from the immigration judge, the immigration court, in which the Attorney General's office, basically said to the BIA, we want you to take another look at this case and see whether or not this individual, Dorman, would qualify for a type of defense from removal called cancellation of removal on the basis of a civil union that was contracted or conducted in New Jersey. And so there's been a lot of discussion in terms of what this means moving forward, whether or not, civil unions or less than marriage or marriages that are contracted in jurisdictions where those are valid at the state level, what that means in terms of its immigration purposes. For the purposes of this presentation, and certainly in terms of moving ahead, the matter of Dorman case does not set any legal precedent. Certainly, it's certainly a positive step that the AG's office, has directed the BIA to take a look at this in the context of cancellation of removal. But essentially, it's it might be a bit of a delay tactic until we know more about the outcome and the fate of the Defense of Marriage Act. The other area that's gotten a lot of coverage in the news media, and for those of you familiar with the complexities of removal, is the area of prosecutorial discretion, where in recent memorandum to DHS officials, the secretaries of the Department of Homeland Security have initiated particular areas of where they're not prosecuting individuals for removal. And there are what they deem positive factors in favor of prosecutorial discretion, and relationships, including same-sex relationships, are deemed as one of these positive factors. Now, there are a host of other positive factors, and so anybody who is in removal proceedings, prosecutorial discretion is certainly an avenue that you should take a look at. You should discuss it with your attorney, and you should be aware that a same-sex relationship is a positive factor in terms of prosecutorial discretion, but there certainly are others, and you should be aware of those, and your attorney should be aware of those as well. But prosecutorial discretion is an avenue of, permanent to semi-permanent relief if you are in removal proceedings, and same-sex relationships are very recently considered a positive factor in favor of the exercise of prosecutorial discretion. Another avenue of relief, we've just sort of labeled administrative closures and adjournments, but essentially they are, they're immigration court tactics that an attorney or somebody who's appearing on their own behalf, per se, an immigration court can avail themselves of. But it's certainly not any form of permanent relief. Essentially what it is the IJ sort of setting the case aside, the IJ being an immigration judge, setting the case aside until some other event occurs. A lot of people have been seeking adjournments until there's a until there's some determination on DOMA, and many people have been successful in obtaining adjournments, but it does not remove the removal order. So you would still, you would still be answerable for that removal order, but you would have your case sort of administratively closed, which is just a procedural sort of technicality. And then I-601 waivers for green cards are waivers, where there are other categories of inadmissibility, which, are typically when you're facing the 3- and 10-year bars, where there's a criminal history or where there's some history of fraud or misrepresentation. And I'm basically going to leave it at that. But again, the takeaway is that, we are seeing some positive steps forward. There's a lot of great advocacy going on this front by some of our allies, including Immigration Equality. And we are seeing, some rays of hope. But it's still a very much case-by-case basis, and none of these should be relied on in terms of overall immigration advice and what to do if you are in removal proceedings. All right, and can we go to the next slide, please?
Adam, are you there?
Yeah, I'm here.
Sorry about that. I got disconnected for a second.
Okay, no problem. We're there. All right, so we're now turning to the category of asylum, withholding of removal, and cat relief, which are all forms of humanitarian relief that are provided under the immigration law, or the Immigration Act, excuse me. We're going to just sort of breeze through this. If somebody believes that they're eligible for asylum or thinks that they may be eligible for asylum, certainly you should contact an attorney. The important takeaway here is that there is a 1-year deadline for filing asylum under the immigration system as it stands. So you need to file for asylum within 1 year of your entry, or there are rather harsh consequences. Basically, there's a bar to applying for asylum, and you would be eligible only for withholding of removal or cat relief. But we want you all to know that you are eligible to apply for asylum on the basis of sexual orientation as of 1994. There are 5 categories through which you can apply for asylum. And in order to be eligible for asylum, you have to demonstrate past persecution or a well-founded fear of future persecution as it relates to your race, religion, nationality, political opinion, or particular social group of which sexual orientation is a recognized group. There have been successes in the for transgender applicants and for HIV-positive applicants, but they do not have the same designation of a particular social group as sexual orientation does. That shouldn't discourage you in any way from talking to an attorney or seeking asylum on those bases, but they are, you are going to have to make separate arguments, and you should certainly contact an attorney if you think that any of those, if you think you're eligible for asylum and you're within one of those categories. And again, as the slide moves forward, I just wanted to remind everybody that the 1-year deadline is a rather strict deadline, and so if you do think that you are eligible for asylum, it's imperative that you apply within 1 year of your entry to the United States. All right, and we are now looking ahead to the end of DOMA. This is somewhat prospective, and it is entirely a guessing game, but I'm going to let my colleague take over from here.
Sure. So then the question we're most often asked in this context is, so now we know what we can and cannot do in the immediate and short-term future while DOMA is still on the books. So what happens if DOMA is repealed? Well, the answer is it depends. At most we can guess what the Supreme Court will do. In the event that it is struck down, the most important takeaway is that, basically don't go running out and filing your I-130s and I-129Fs without speaking with an immigration attorney who is familiar with these issues, because the ability to have our marriages recognized is not going to be automatic. Up until this point, the recognition of marriage for federal immigration purposes is determined by the place of celebration. So, our best guess for purposes of this presentation, short of finding out what the Supreme Court's going to do, is that we will return to that long-held tradition of deferring to basically the states. If it's recognized in the state where it was entered into, so it was valid where performed, it was not in bad faith, and not contrary to public policy in the state where the couple is residing or intends to reside, then it should be valid for federal immigration purposes. Now, that being said, there's a lot of differences among the U.S. states, in addition to the foreign countries, about whether or not a marriage is valid, or same-sex marriage is valid if performed there. There's some questions about establishing the not bad faith, or rather good faith, and there's also questions surrounding whether or not it's contrary to the public policy of the state where you will be residing. A side note, like we talked about before regarding matter of Dorman, civil unions and anything less than marriage recognition, it's uncertain, but it's probably unlikely that they will be recognized as marriage for immigration purposes, for the simple fact is that they're not marriage. And there are, in fact, of the states that offer civil unions or domestic partnerships in the U.S., only 2 don't also have some either constitutional amendment or law or provision that specifically limits marriage to one man and one woman. We call them mini-DOMAs. So even if a couple is civil unioned, that doesn't necessarily mean that it will be valid where performed as a marriage or will not be considered contrary to public policy. So we'll go through those in a little bit more detail. Where same-sex marriages are valid where performed. Currently, at the time of this presentation, there are 11 foreign countries: Argentina, Belgium, Canada, Denmark, Iceland, the Netherlands, and in the Netherlands specifically, that even though in the country they're valid where performed, they are recognized throughout the Kingdom of the Netherlands. So, for example, Curacao would be a marriage entered into in the Netherlands would be recognized there. But in Curacao specifically, they are not valid if performed there. Norway, Portugal, South Africa, Spain, and Sweden. 9 states after this election, and once the laws go into effect in 2013 for Maryland and Maine, and next month for Washington, we have 9 U.S. states and the District of Columbia. So if it was validly performed in one of those 9 states or the District of Columbia, then it will be considered meeting the first criteria for marriage purposes. Also, Mexico City allows recognition, or rather, same-sex marriages performed in Mexico City are valid if performed there, and they are recognized not, it depends on the state where you're residing, whether or not it'll be recognized there, but in Mexico, around there, for other states within Mexico, they do recognize marriages there that are performed in Mexico City. The not bad faith argument, the second prong of this analysis of the traditional recognition of marriages for federal immigration purposes that we are giving information about in the event that DOMA is struck down or repealed, the no bad faith. So the marriage cannot be fraudulent, cannot be entered into solely for immigration benefits. This is the case for all marriages. Right now, specifically for heterosexual couples, this is pretty much the criteria why they do the marriage interviews. They want to, in addition to making sure that the marriage license is real, they want to make sure that this couple, appears and carries themselves as married. There are special considerations for marriages where one spouse identifies as bisexual. There may be some, gung-ho immigration officer who's decided to do a little background research and a little FDNS online investigation into whether or not this couple is who they say they are, and they see maybe someone's MySpace or Facebook profile lists themselves as bisexual but married to someone of the opposite sex. They may require some more evidence that this is, in fact, in good faith. The offensiveness of that aside, it would be a good idea and it would behoove you to, prepare all the evidence of the bona fides of the marriage accordingly, just to, a practical consideration for folks who self-identify as bisexual. And then the last prong, not contrary to the public policy in the state where the couple resides. So, for the U.S. 50 states, there are basically only two jurisdictions that do not have same-sex marriages available for folks in the state, but will recognize out-of-state same-sex marriages. That's Rhode Island, which specifically allows for it, and New Mexico, we say arguably, because there's just no laws on the books there in this regard. So the idea is that they will usually, with comedy, will recognize an out-of-state marriage if it was valid there. So in theory and through anecdotal evidence, New Mexico would recognize an out-of-state marriage, so it would not necessarily be contrary to public policy. In general, and there are some varying considerations depending on the circumstances of that state and what other laws are on the books for that state, whether or not it would be contrary to public policy is a good indicator of this is whether or not there's a constitutional amendment banning same-sex marriage, or rather limiting marriage to, or rather marriage recognition to just one man and one woman. There are currently 31 states with such restrictional constitutional amendments, or anti-gay constitutional amendments in place. On this list, we've starred California and Nevada and Oregon because these states, even though they have broad domestic partnership or civil unions, which are very similar to marriage, they're not marriage. And specifically, these states have gone even further and have said that there's a constitutional amendment banning recognition of same-sex marriages, but here is your civil union or domestic partnership. So even if a couple is validly married in another state or country and reside in California, Nevada, or Oregon, and potentially have their relationship recognized as a civil union or domestic partnership, the marriage is still against public policy for immigration purposes because of those constitutional amendments. And I hope that is clear. For other states that don't have constitutional amendments limiting marriage recognition to opposite-sex marriages, they have laws on the books through legislature or through popular referendum. This includes Delaware, Hawaii, Illinois, Indiana, Minnesota, Pennsylvania, West Virginia, and Wyoming. We've starred as well Delaware, Hawaii, and Illinois, which either have broad domestic partnership or civil union, but there are laws on the books limiting marriage to one man and one woman. So this would, in general, be contrary to public policy, and therefore the marriage would not be recognized for immigration purposes. And there's really only New Jersey and Rhode Island that have civil unions without these restrictive measures. But like we said earlier multiple times, civil union and domestic partnership aren't marriages at this point, so they would not be, just a striking down of DOMA would not necessarily yield, immigration benefits for folks with civil unions in New Jersey. An important point, too, with these certain states, like, for example, California, that we starred on the last page here, Proposition 8 has been all over the news for the voter-approved initiative to amend the Constitution of California to limit marriage to one man and one woman. Then there was that was after and taking away the California court decision that said that domestic partnerships, violated the Constitution and took away the marriage rights of those already married in the state. So, for a summary and maybe for an example of the complexities involved should DOMA be overturned, if a couple is residing, a married couple, let's say married in another state, is residing in California, just because DOMA is overturned does not mean that their marriage will be recognized for immigration purposes if Proposition 8 is still in the books, because Proposition 8 is evidence against public policy in the state where the couple resides. So we're on this last slide before we go to questions. And by the way, while I'm going through a few examples, if you have any questions, please feel free to type them in through your sidebar here. There's a drop-down window for you to enter in any questions you have, and we'll address those at the end. While I'm going through a few examples, here we go. For example, if a couple, like I just said, married in New York and they reside in California, and they're a binational same-sex couple, which means that one spouse is a U.S. citizen, for example, unless both DOMA and Prop 8 are overturned, this marriage will not be valid for immigration purposes. For, let's say, a couple married in the Netherlands. They reside in the state of Maryland, and we fast forward to 2013. They're a dual foreign national same-sex couple. So they both are from the Netherlands. They got married in the Netherlands. They just moved to the U.S. maybe a few years ago. They're in the U.S. Maybe one is on a student visa and one is on a work visa. And Maryland, 2013, now recognizes, or rather allows for same-sex marriages. There's certainly valid where it was valid where performed in the Netherlands. It wasn't bad faith. They've been together for 10 years, and they meant it. It's not for immigration benefits. The state where they're residing, it's not against public policy. There's no laws on the books or constitutional amendments preventing Maryland from recognizing that marriage. So what does this mean for this couple? Well, since they're a dual foreign national couple, it doesn't mean that one could file an I-130 or an I-129F for the other. What it does mean, though, is that if one of the spouses wanted to, say, become a dependent H4 or L2 or E2 or O3 or what have you, and reap the benefits of that, which include but are not limited to not having to extend every 6 months in the B2 status, which can be quite daunting, that option would be available to them. For a couple who are married in Massachusetts, for example, and reside in Florida, let's say that DOMA is repealed and the Florida residing U.S. citizen wants to file a green card petition for their spouse. This would not be valid for immigration purposes because Florida has a constitutional amendment limiting marriage to one man and one woman. So it would be against public policy, even though it was in good faith and it was valid. It was valid where performed because of these public policy considerations. In general, we're not saying this is going to be the definite case for every single situation, but in general, there's an argument that this is against public policy in Florida. This could be subject to change depending on the outcome of the Supreme Court case or other, This could change depending on the outcome of the Supreme Court case, or if there's any specific ruling on another case before the Supreme Court. The Prop 8 decision, for example, if they do decide to take it and do decide to make some nationwide sweeping decision, this could change. Or maybe there will be some USCIS policy on what is and what is not contrary to public policy in terms of, does it have to be some law criminalizing homosexual activity or recognition? What about if the state recognizes discrimination claims based on sexual orientation, or has a anti-discrimination provision in their housing code or something like that? So it's going to depend on every factual situation. The takeaway from all of this is that the end of DOMA is wonderful, and we're all looking forward to it, but it does not necessarily mean that you should run out and file your I-130 or I-129F for your same-sex spouse or partner, for that matter, until you analyze the specific situation and specific facts of your case and the laws that apply in your state where you are married, or the country where you're married, the state where you reside, and the other considerations that you have regarding your non-immigrant status or immigrant status. So that's pretty much it for now. If there are any questions, we would both be happy to respond. So if you have a question, again, you can type it into your drop-down box for the chat window. Feel free to ask away. Let's see, we have a question here. The question is, how to prove good faith when we're forced to live apart because of DOMA? That is a very excellent question. Adam, do you want to take the first stab at answering this? The question again, how do you prove good faith whenever you're forced to live apart because of DOMA? I assume that the person who asked the question means how do you establish the bona fides of the marriage in instances where you have been forced to live apart.
Yeah, that was my assumption as well, and that is a very good question. Typically, the way to establish good faith is to establish a life together, and presumably, while you may not be able to permanently reside with one another, you will have acquired a semblance, at least, of a life together, and so there are many ways you can do that. The practical ways are you can do that if you have joint bank accounts, and if you have joint leases together, either in a foreign jurisdiction or in the U.S., which for the foreign national, again, you have to be careful about in terms of your immigrant intent if you're using non-immigrant options to come to the United States. But joint bank accounts and joint leases or jointly held property and things of that nature are very good evidence of the bona fides of a relationship. There are sort of, go ahead.
Sorry. I was going to say I wanted to add to that too, like some additional evidence that you might consider. Even if you cannot specifically show that you've been physically living and with each other in the same place because you've been forced to live apart. You may have phone records that you've talked to each other long distance. You may have letters to each other. You may meet somewhere in between the two countries if you're not able to live in those, just for a short trip or something like that. Communications with the other person, I think, is a key indicator. You probably at least had spent some time with each other before the forced and unfortunate and terrible and sad and unjust separation. All of these things are considerable, and the evidence to establish the good faith nature of a relationship, it's not an absolute 100% requirement that a person lives with the other person. There are plenty of instances where it's completely reasonable, and that's why it's a case-by-case basis, where people might live apart for other reasons besides being forced to be separate because of DOMA. For example, instances where maybe two professors are married and one is on sabbatical or one is doing a semester teaching as a joint lecturer, maybe living in a separate area, or potentially is constantly traveling for work or is in the military and is traveling. There are plenty of different ways to establish that on a case-by-case basis.
And I would encourage you also, or encourage anyone who's in this particular situation to be creative as well. I think that if there are, if there's evidence such as invitations to, events or parties or, other people's engagements or weddings or such, where you're listed together or as a couple, I mean, certainly I would submit that as evidence. If you have photos of yourself, particularly at family celebrations, around the holidays, things of that nature are also really good ways to show the bona fides of a marriage. And if you can show it over a period of time, I think that strengthens the application as well.
So there's a great question here. In 2008, before Prop 8 went into effect, same-sex couples were able to marry, and they did not take back those marriages. In other words, those who were married were able to stay married in California. What does this mean for those couples if DOMA is repealed? That's another good question. The constitutional amendment limiting marriage to one man and one woman would be taken into consideration along with the fact that those who married before that went into effect are able to have their same-sex marriages recognized in the state of California. So for those specific subset of same-sex marriages that were valid when entered into in California, were entered into in good faith, and the question then becomes, are they contrary to public policy? Well, that would depend on the individual facts of the case. I would certainly argue as the attorney that it's evidence that it's not contrary to public policy because they are specifically recognized, and I would imagine that would prevail in those specific factual circumstances, all else being equal. There was another question, too. For immigrants who have overstayed their visa for longer than 12 months, what options are there aside from the 10-year deportation penalty? So for individuals who have overstayed for more than 12 months and then subsequently depart the U.S., trigger the 10-year bar to reentry. There, in certain circumstances, all else being equal, and let's imagine DOMA doesn't exist anymore, at least for the current, for example, for heterosexual married couples who apply for a green card for the other, or petition for a green card for the other person, and then they are in their adjustment of status process, the interviewing officer at USCIS has the discretion to allow that person to file a 601 waiver for grounds of inadmissibility from within the U.S. in the adjustment process. The normal process is that they would have to go abroad for immigrant visa processing and then file the 601 there. There's talk about changing that to stateside for immigrant visa processing, but for this specific question, in the adjustment context, if the officer felt it were appropriate in their discretion, they can allow the person to apply for a 601 waiver for grounds of inadmissibility. One of the grounds of inadmissibility that is waivable as a matter of discretion with the 601 is the 10-year bar to re-entry. This does not necessarily apply for visa waiver entrants. There's a little bit different restrictions there, but this is, for example, if someone overstays a F1 visa or a B1 or something similar, and even in certain circumstances, the visa waiver, the 601 discretionary waiver may be available from within the U.S. through the adjustment process, if allowed, or after the immigrant visa petition or immigrant visa processing has started in the consulate or embassy abroad. And another question here, and maybe Adam, you can pontificate upon this. Since the question of same-sex marriage constitutes one of the most unsettled areas of the law, do you think as lawyers that DOMA can reasonably be abolished?
Pontificate indeed. I think this is an area that there's a wide variety of scholarship on. There's a lot of opinions on both sides of the aisle. The question is one of constitutional law, and constitutional lawyers are a garrulous sort, so there's volumes and volumes on this out there. My particular opinion is, and I think that there's sort of at least somewhat of a consensus in the gay community, is that yes, DOMA is sort of in its death throes. The outcome, I think, is much more in dispute. I think attorneys who are working in this particular area feel confident for the first time, really ever, to say that DOMA might be overturned really soon. On November 30th, the Supreme Court will go into conference to decide which of the near 10 cases that are challenging DOMA and are currently on petition for review before the Supreme Court. They will either take one of those cases, or maybe consolidate some cases, or not take any of those cases, and then we'll be sort of stuck with the same situation that we have now. But it's highly anticipated that they will take a case. There's a really great article by Linda Greenhouse in the New York Times today, who I think is perhaps much more qualified to talk about this than myself. She believes that Windsor will be the case that is taken. That's the case out of the Second Circuit. It's a very favorable case in terms of the arguments that the justices made in overturning DOMA, or in striking down DOMA on equal protection grounds in the Second Circuit. It applies a heightened level of scrutiny, which is good news in terms of the opponents of DOMA. And so, that was a very surprising decision. And just as a side note, it was a decision that was issued by a Bush 41 or Bush Senior federally appointed judge. So even conservatives are looking at this, and saying that this is difficult to defend. We're cautiously, we're lawyers, so we're always cautious, but we're cautiously optimistic that, that DOMA might be overturned soon. And that's one of the reasons that we're holding this webinar. But I do, want to caution you that just because DOMA may be overturned doesn't mean you should take rash action. which is why we've gone through these options in detail so that we're preparing for when DOMA may be overturned, but we're not acting on those on that assumption at this point. And I don't know if you have anything to add, but feel free.
No, I appreciate, and you know, I think that, you know, it fundamentally comes down to the question of whether or not Section 3 of the Defense of Marriage Act violates, you know, equal protection. And, you know, this may be unsettled in the fact that the Supreme Court has yet to rule on it, but the resounding opinion of lower courts and Federal Circuit Court of Appeals is that, yes, it does violate equal protection. You know, as we can see in the practical, on-the-ground level, that certainly disadvantages and complicates matters for U.S. employers who are trying to bring the best and brightest talent. It complicates matters for U.S. universities and research institutions who are trying to bring in folks who are the best and brightest, and yet running into roadblocks because their spouse is the same gender as them. And, you know, it's costing folks a lot more money to have to get into all these ridiculous complexities and pay all these additional filing fees to keep extending, for example, a B2, or, you know, to hire a specific attorney who is an expert in the area who can help them navigate through this. So I think that it is reasonable, and, you know, we shall see. Unfortunately, we can't answer any of these other specific questions. If you would like to have your question answered individually by either Adam or myself, you can email us. Our email addresses are on the screen, jshepard@wolfsdorf.com. And Adam's email address is here as well. His number and address are on there, as are mine. We would like to...
And just a quick note, sorry, it's Wolfsdorf, WOLFSDORF. JJ, there's a typo on your email address there. So make
there
sure
totally is. Thank you. Cheers. Great catch. Wolfsdorf, not Wolfdorf. We will fix that before I will answer this last question. Yes, we will send out the slides after we fix a few typos that I caught other than the S missing from my Wolfsdorf. Also, please follow us on Facebook at www.facebook.com/800VisaLaw, and again on Twitter /Wolfsdorf, spelled correctly. With that, thank you very much for your attention and time. If you have any other questions, please feel free to give us a call or contact us. And best of luck to you all, and keep watching the news for updates from the Supreme Court and otherwise. Take care and have a great day.